Hello, hello. Welcome, everyone. I see a few people are joining right now. We're going to be starting shortly. Just going to give it a few minutes for everyone to join. But while we're waiting, feel free to say hello in the chat and let us know where you guys are joining in from. Also, tell us what you're hoping to learn today. Where is everyone from here? Oh, cool. BC, Ottawa, Toronto. I'm actually from East Coast out here in Newfoundland. Jordan, where are you from?
I'm from Richmond Hill, Ontario, which is just north of Toronto.
Right on, right on. Yeah, I want to thank everyone for joining. I appreciate your enthusiasm joining early. As I mentioned, we'll just give it a few more minutes. I'm hoping everyone can hear me okay. Let me know if I'm too loud. My wife always says I speak too loud, so this tone is good. Give me a thumbs up. A lot of people from Toronto and Ottawa today. Right on. So for everyone that's joined right now, just get a little bit familiar with the page. At the bottom, we got a Q&A. We have a chat. So we're going to try and make this webinar as interactive as possible. Obviously, lay some time for some Q&As at the end. But if you have any outstanding questions, by all means, jump in there. Would love to hear from you guys. We'll try to get through all the questions as good as we can. And use this webinar as kind of a networking opportunity. Feel free to chat amongst each other. You have any East Coasters out here? Montreal, I see there. Ottawa, Toronto, BC, Edmonton. That's awesome. Awesome. Halifax, right on. Anyone have anything cool they want to learn about today? What they're most excited to hear? I'm super excited about this webinar here. We'll just give it maybe 1 or 2 more minutes. We have a couple hundred people joining today, so we'll just wait for everyone to join. Maybe we'll start in about a minute or so. Again, thanks all for joining. I would love information regarding the best practices leading up to terminating employees. That's a great one. Do we have some Humi customers here as well? How are you guys liking Humi so far? Yay. Well, we're always striving to be better, so give us your feedback. All right. Well, we have about 100 people joining. I think this, we had roughly about 250 that registered. So I just want to give it another minute or so. Just so you guys know, we do not have a hard stop. We're going to try and make it for about, how long is it, Jordan? 45 minutes or an hour? But we might be able to keep it open a little bit longer for a longer Q&A if you're willing to stick around. And for those that are not Humi customers that are interested in exploring Humi, we'll definitely provide you with a demo booking link at the end and also a follow-up email as well. So. Oh, lots of great input there, everyone. Jordan, are you getting all these? Hope you can answer all of these today. All right. We're going to start in 30 seconds, I'll say. Cool. All right, well, I think we are ready to begin. Okay, so let's get started. So, good afternoon, everyone. It's 2:35 my time, 1 p.m. Eastern Standard Time. I guess good morning for those out west. Thank you guys so much for joining us today. My name is Matthew Byler, and I'm the Senior Manager of Strategic Partnerships here at Hume. I'm thrilled to be facilitating this webinar where we're going to be diving deep into the crucial intersection of HR and employment law and how it all plays out as a pivotal role in the success of your business. Today, we have the privilege of hearing from Jordan Rodney, who's the VP of HR and Legal Services at MaxPeople. He's also the founder of Rodney Employment Law. So he is an expert in the field with a wealth of knowledge and experience that I'm very confident is going to provide some invaluable insights today. For Hume, we've formed a terrific partnership with MaxPeople, driven by our shared goal of providing you guys with guidance and support you need around HR and legal matters. Hume being a truly Canadian employment platform, we help businesses across the country engage and drive their teams. While we do offer a robust SaaS technology with the essential features of an employment platform, we also recognize that technology alone is not enough. So that's why we rely on partners like MaxPeople to bring the essential people touch to HR and further support our customers. Today, Jordan will be laying the legal foundation with a focus on HR and employment law for business success. Now, before we dive in, I do want to let you all know that today's webinar will be interactive. So we'll be opening up the floor for questions, and we're also going to be launching a couple polls throughout the session. We're going to do our very best to address all of your questions as they come up, but if we can't get to all of them, we'll certainly get back to you guys after the meeting or after the webinar. So with that being said, I'm thrilled to introduce you guys to our host or our presenter here, Jordan Rodney.
Thank you very much, Matt. And a couple of preliminary things I just want to say. Will Reyes from Hume and Joanna Van Bilsen from MaxPeople. Matt and I could not have done this without both of you, so thank you very much for that and for all the behind-the-scenes stuff. And Matthew, I appreciate the opportunity to do this. I think this is a great audience. The way that I think of it, Matt, is, Hume is the technology to facilitate the management of employment. And MaxPeople is really the advisory group that can support Hume and kind of bring it all to life and socialize it and make it happen. And the other way to look at it is Hume is it's a technology platform. It's a great platform. We actually use it ourselves with our HR consulting firm. We've positioned it with many of our clients. But Hume is often, it's processing, it can be black and white. HR and employment law, the last thing they're not is black and white. It's shades of gray, and that's where MaxPeople comes in. It's as you said, the people side of it. So many of you know Hume. You're either clients of Hume or prospective clients of Hume. I just want to tell you a little bit, very briefly, about MaxPeople, who we are. We're, again, an HR consulting firm. We're based in Markham, Ontario. We've been around for 20 years. We have over 150 years of combined experience, and we offer services in 4 areas, Matt. Fractional HR for small and mid-sized companies, recruitment, training, and employment law. And I wear 2 hats here. I'm both an employment lawyer and an HR professional. So I hope to bring a legal perspective today, obviously, but with a practical HR spin as well. And we're gonna there's a checklist. We're gonna talk about this at the end. It's a good resource for you. We're going to come back to this download, but there is a complimentary checklist if you want to scan this, and we'll talk about it later on. But what we're going to cover in the next 45 minutes or so is going to talk about recruitment and the difficulty of finding talent today. Obviously, it's increasingly difficult with everything going on over the last few years. We're also going to talk about employment agreements and a little bit about employment status, Matt, and why this is so important for those on the line. And then we're going to talk about the ins and outs of performance management, discipline, and terminations. But we have a bonus topic, Matt. Other than these three topics, we're going to talk about whatever the audience wants to talk about. As long as it's relevant to the workplace, we're going to talk about it. And if we can't answer your questions in the next 45 minutes, we will make a commitment to answer your questions post today's session. So again, make it interactive. As Matthew said, we want to give you the opportunity to ask whatever you want to know. And before we get into recruitment, the workplace has fundamentally changed in the last few years. We all know, I'm not even going to mention the C word, what's happened, because that's over. COVID is over. But whether it's the economy, whether it's changing perspectives on work, it's very challenging to be an employer today. It's challenging to be an employee in some ways, but it's really challenging to be an employer, challenging to be a leader. And the goal today, what I want you to leave here with, and I think what Matthew wants you to leave here with today, is how can you minimize risk in your organization while being practical and communicate with transparency? That's really what I want to leave you with here. And if there's one or two things that you learned about how to minimize risk for your business, then I think it's been a successful webinar. So that's what I want to, and maybe I can, to kick off recruitment, let's just go right to the polling question, and I'll ask Will to pull up the polling question. We want to ask the audience, recruitment in the best of times is really difficult for a wide variety of reasons. We just want to hear from people, what's been the most challenging aspect of recruitment for you? So maybe just take a minute and just type in the box there, what's been the most challenging thing for you? And we'll just give everyone a minute here to do that. Yeah, I'm just looking at some of the answers coming in here. Healthcare, so finding nurses. I think it's fair to say that that recruitment, regardless of the industry, has been very challenging. Both the attracting talent and finding talent. And I'll give you an example. Maybe we can close the poll now. I'll give you an example. One of the things, there's a number of things that have happened in the last few years that was inconceivable when I started my career 25 years ago. And this isn't just factory, blue collar workers. When you set up interviews and let's say you have 5 interviews and only 3 of the 5 people show up, either because they've had other offers or you offer jobs to people and it's like, well, I've been offered another job, a better offer, an offer that lets me work from home. This is stuff that we just did not see, in the past. So it's been very challenging. Obviously, with technology, it's been challenging, and it's going to continue to be challenging. So I have this philosophy, Matthew, about hiring and firing, and I want everyone on this who's here today to remember this, because I think it's important and it's very simple. Hire slow, fire fast. And that's something that I would encourage the group. So don't settle in the hiring process, because if you settle in the hiring process, you're probably going to be disappointed. And if you have a problem employee, obviously we're going to get into performance management. you want to give people an opportunity to improve their behavior, but at the same time, if it's not working out, you probably want to move on at that point. So I want to talk a little bit about the candidate experience in recruitment and what that means. And this is kind of like what employers need to do to make to make your company attractive for employers. And maybe Matthew, I can ask you a question, like as the senior manager of strategic partnerships at Humi, what do you do at Humi to kind of make the candidate experience attractive?
Yeah, like I can talk about that for hours to say, but let me start back with a quick story. Like before me being a partner manager, I was actually an engineer, and I remember my first professional career. My onboarding experience was, hey, here's a bunch of paperwork, right? Fill it out, right? And I'm sitting down first day filling out a bunch of paperwork, and it just gave me the worst impression of the business. And I feel like if you really want to retain your candidates and then employees, you want to really give them a good experience, and that really just starts from the application process for an individual, right? There's been countless times where I've actually abandoned applications, right, just because they were too long, they were too robust, asking for way too much detail. I find a lot of times you're applying just from your phone, right, or you're on your desktop where it's more accessible. It's just too hard to collect all that information and take all that time, right? And then once you're through the interview process or going through the interview process, you really want to make it exciting, engaging, and professional, right? And as Jordan alluded to, take the time, right? Really, share that experience with that candidate. And then furthermore is really that onboarding experience, and that's where Humi really helps out is making it digital, making it modern, accessible, easy to follow along. It really puts a really good image on your business, right? When it's modern like that, where it's super easy to follow along. That's something that we've done through Humi. We use our own products as well. I really enjoy the onboarding experience, but also just from an administrator standpoint, you're collecting all that data. You're collecting all the appropriate documents, those legal informations that maybe Jordan might allude to later on. It's all there in one place, right? Even with benefits enrollment, it's one single location to really manage that employee.
Yeah, and that's great, Matt. And one of the things that Humi allows you to do is get this stuff done in advance, so the employee's not having to worry about it, on their first day, in their first week. But they can do their training online, and you learn about the employee. We have this process where the employee starts, and there's a bunch of questions that we ask the employee to fill out. So when they come in, it's like you already kind of know that employee before you get to know them, and it's really helped our process. The other things I want to say that you should be doing as a company, it all comes down to the EVP, the employer value proposition. What does your company offer that make it attractive for the prospective candidate? You also want to have clear job profiles. You want to be transparent, as Matt said in the interview process. You want to have, if you're having an on-site component of the interview process or the orientation process, you want to make it meaningful. You want the person to meet as many individuals as possible. And you want to have a consistent brand message. You want to have a brand message throughout the process. And the last thing I want to say, and this is from our head of talent, who always tells me that if the candidate is not successful, you always want to be specific in getting back to them, because you never know. It's a small community, and if you're not going to move forward with them, you always want to kind of close the loop. So that's the candidate experience. But on the flip side, there's also been a significant shift in candidate attraction over the last few years. And why is that? There's been technology advancements, obviously, with social media. There's been changing demographics. There's been COVID, societal values. The world of work, as I said, has fundamentally changed. And I don't know, Matt, if you had
Yeah.
any questions to ask here, but maybe
Yeah, I was trying to raise my hand here over here
yeah.
because when I'm thinking about like, what are those legal implications when people are using these like social media platforms for recruitment?
Yeah, I mean, it's a great question, and we get asked it all the time in both our HR and legal practices. As a hiring manager, you absolutely should be going to social media as part of the recruitment process. This is why I tell my kids, Matthew, that are like in their like late teens, early 20s, like don't be posting pictures of you partying on the weekends or at university on Instagram or Facebook, because it stays there permanently. And you should definitely, you could learn a lot about an individual through social media. So it's absolutely legal. The one thing that you got to be careful about in the hiring process is if you're going to disqualify someone and not bring them on, it can't be because of what they posted on social media. So you'll have to find another reason why you're not going to bring the person on, but it's something, it's a valuable tool that employers and hiring managers should use, managers of any kind. The other thing that I would say is what candidates are looking for today, Matt, and this is in the research, is they want a company that aligns with their personal values. So a lot of times this was not the case in the past, but it's very much the case today. They're looking for that elusive work-life balance. And I think there's, 150 plus people on, on the webinar today. If I ask people, how do you define work-life balance? You get 150 answers, different answers. So, but it's like, what does work-life balance mean for that individual? They want to have a positive company culture. Culture eats strategy for breakfast. Michael Porter said this in the early 90s. A famous professor said, culture eats strategy for breakfast. Nowhere has this been more important than during COVID. And you also want to have comprehensive and flexible benefits. You don't want to have the traditional benefits plans. And this is something, again, you can use Humi for benefits, for the overall benefits. And then, what MaxPeople does with our clients is we look for the most cost-effective benefits plans for our clients, and we source them out, and we help our clients, make sure that our client staff members are engaged. And then the last thing I would say is candidates are looking for innovative companies. They're looking for companies to be innovative and progressive, and that's what's important for them today. I want to move on to, I want to just change focus for a second. I'm sure there's a lot of questions on recruitment, and we'll come back to it, but I want to move on to agreements, classifications, and policies. And what I like to say, Matt, is if you're a small business or you're a startup business, or you don't want to invest a lot of money, maybe beyond technology in human resources, there's something called the three-legged stool that I would recommend that employers and people on the line keep in mind. These are the must-dos. And what those entail is one leg of the stool is agreements, making sure you have good agreements in place. The second leg of the stool would be your key workplace policies. And the third leg of the stool would be compliance. These would be the must-haves. And, again, this is all about saving money. So if you have compliance policies, workplace policies, and agreements in place, it is going to contribute to a significant savings on your bottom line. And it's actually, the employment agreements, I would say, are the most valuable tool that employers have at their disposal. And I'm going to talk about some of the changes in the next slide over the last, 3 years, let's say. It's been significant changes over the past couple of years. There's different kinds of agreements, Matthew. There's indefinite employment agreements. There's fixed term employment agreements for a fixed period of time. And then there's contractor agreements, like when you have a contractor working for your business, and you really need to be super careful that you're not classifying someone as a contractor, but they're really an employee. Because if that's the case, a lot of individuals say, oh, I want to be a contractor. I want to invoice the company. But for all intents and purposes, they're an employee. So you got to be super careful when you're doing the classification. And this is something that you should have an employment lawyer look at on a regular basis. You had a question there, Matt?
Yeah, just a quick question around, the creation of documents and employment agreements and all of these policies. Like, how often should a business, review these agreements and policies? Is it set it up and forget it, or should you be reviewing this on an annual basis or a quarterly basis, or what? Tell me more about that.
I mean, we have a very we have a great process internally where our HR and legal teams work together, and if there's a significant case that comes out or a significant piece of legislation that comes out, we will make amendments in real time and get these out to our clients so our clients don't have to worry about it. It's also, again, talking about Humi here, there's new policies that you want to introduce. You can post these on Humi. You don't have to go through the process of emails and Slack, and you could literally go on Humi, post the policy, and give a date for sign off, and it's captured in the system. So that's something that has been of great value to our clients. But to answer your question specifically, one of our lawyers, said, this should not, it's similar to a tune-up for a car. And it should be treated as such. So the same way that you want to tune up your car, you want to tune up your agreements, your policies, and your compliance. And we introduced recently an LMS system, which has all the compliance courses and a number of other courses that you literally go on and it tracks it in real time. And it's a fabulous add-on for our HR services. And again, it integrates, it complements Humi beautifully in terms of, time off, policies, performance management, onboarding. It's a wonderful integration. And an LMS, for those that maybe don't know, it's a learning management system. And what it allows you, it's a portal that allows you to have all your training in one centralized section. So I want to turn it over to Will now, if she can just pull up the next polling question on employment agreements. The question we're asking here is, have you had your employment, so this is a very timely question, Matt, have you had your employment agreement reviewed in the last year? And so it's just kind of a yes or no. So if you don't mind voting, we'd really appreciate if you can just click that off, and then we will give you a minute here, and then we'll close the polls. And I hope here the answer is an overwhelming yes, but we'll just give it another 10 seconds here, and then so Will, we can close the poll. It looks like the vast majority of people have voted. And this is good. So it looks like almost 2/3 of people have had their agreement reviewed in the last year. So that's great. But for the other 40%, you should consider doing that, shortly after the session. And for those that have done it in the last year, I don't think there's anything wrong, Matt, in doing it twice a year. And again, if there's big cases that have come out, you want to do it, on a regular basis. So that's great, Will. That was a very timely question. Mm-hmm. And I want to just give the group here just a very quick overview. Now, I'm going to talk about Ontario legislative developments here, but I know there's a lot of people from across Canada, so think of it as the spirit of where the case law has gone and the legislation has gone. Even though these are Ontario cases, I will speak later on, Will and Matt, about some other cases in Nova Scotia, in BC, but I want to talk about some Ontario cases, and just to show that employment agreements really do matter. So the first case was in 2020, and the ONCA stands for the Ontario Court of Appeal. So this is the highest court in the province. And the case, basically, the main lesson in the Waxdale case, this is one of the most significant cases in the last 20 years in employment law in Ontario. What it basically says is, if your employment agreement violates the Employment Standards Act in the termination clause, then the agreement is invalid. And what that means is the company can no longer rely on the employment agreement at the time of termination, but you become what's called a common law employee, and which means you're entitled to a higher severance package. And I'm going to talk, Matt, in the next 20 minutes about what a common law employee is. But that Waxdale case says if there's a violation, you can have language to save the violation, but it changes the status, and it's going to cost the employer more. 2 years later, the Slavkin decision comes out, and it builds upon the Waxdale decision. And in this case, the agreement was perfectly, fine, and it had good language, but the confidentiality and conflict agreement appendix that the employees had to sign off on actually violated the Employment Standards Act. So it took the Waxdale decision and it kind of expanded it into like confidentiality and conflict of interest. So again, making it harder and justifying why these agreements need to be updated. And then lastly, I wanted to include a 2024 decision. This is the Dufault case, and this caused the heads of HR people and employment lawyers to spin because the court said that there's language in the agreement that said you can terminate at any time or within the employer's discretion. So those phrases at any time or within the employer's discretion were deemed to be in violation of the Employment Standards Act because, Matthew, if someone goes on pregnancy leave or medical leave or a approved leave of absence under employment standards across Canada, you don't have discretion to terminate them at any time. Therefore, it's a violation of the legislation. So very technical, but it has caused a rewrite of, thousands of employers' employment agreements and chaos in the employment law community. So back to your question, always do an annual review. And it's something that at a minimum, an annual review. When you're talking about policies, some companies, Matthew, don't like doing policies. They're like, why do I need policies? Because I like the flexibility. Well, there's compliance policies. These are the policies that, you must have. These are things like across Canada, the accessibility legislation, respect in the workplace, like harassment and violence legislation. Quebec has psychological harassment. This is under the Health and Safety Act, a health and safety policy statement. This is something that you don't have discretion to have that. You must have it. Many provinces require a pay equity or employment equity policy, a code of conduct. These are policies that you must have. And if you don't want to have them, at least have the core policies that you need to have. Then there's the best practices, Matt. Things like, dress code, acceptance of gifts. And I highly encourage everyone on the line here, if you're in the area of policies, that you review them, that you look at them, that you have them, assessed, because they're constantly changing. And really important, going back to the employment agreement, you don't want to put policies in anything that your employees sign because your policies are going to change over time. They're going to change with society. So you want to have them. And this is, again, where HUMI is very valuable because as policies are amended and introduced with legislative changes, you could use the technology of HUMI to kind of integrate them and then use a company like MaxPeople to socialize them in your workplace. Because a lot of times, policies are only as good as how they're brought to life. And there's very different ways to do this through a town hall meeting, through a weekly huddle, through a team meeting, through sign-offs, but you want to bring them to life. And you want to have, the reason you want to have policies is you want to have a standard, Matt, that you can compare policies to. So if you don't have any policies, it's a free-for-all. But so, for example, Matt, suppose within an organization, employee A is a great performer and they want to take a personal leave of absence to do a family reunion overseas. And you're like, yeah, this person's a great performer, so we're going to give them the leave of absence. Then the other employee who's really not doing very well, has been there for a year and a half, comes forward and they say, I want a personal leave of absence. I want to do a course on, training and development. And you're like, this person's not a good performer. If you don't have a standard to basically compare that to, then employee B is like, well, why did you grant the first employee a leave of absence, but you didn't grant one to me? If you have a policy, you have a benchmark that you can compare it to. So that's the example I always like to use for policies. And one of the policies that is mandatory in Canada is the duty to accommodate. So to have an accommodation in the workplace policy. And the key thing, what I want to say with accommodation is, it's a few things. This is the growth of this in the last 5 years has been staggering. About 85% of accommodation cases, Matt, are disability related. whether it's physical disabilities, mental health disabilities, substance abuse, chronic fatigue syndrome, diabetes, cancer diagnoses. Um, it's a very broad definition for disability. What you need to know for those on the line about accommodation is all parties need to participate. So often as employers, we make it easy. We don't say to the employee, you have to come up with options. It's an employee's obligation as much as it is a company's obligation. And our law firm right now is dealing with, we must be dealing with 100 files dealing with accommodation because it is such a common area now for employees to push the envelope. And you have to be very careful because it could result in significant liability. You have to think outside the box. You have to be creative. What you can't say, Matt, as an employer or manager is, oh, I can't accommodate. You have to, what I like to say, turn your mind to accommodation. You have to, give people an opportunity to kind of, what can you do and be really creative? Because honestly, with the implementation of COVID, before COVID, in our 20-year career as an HR company, we might have done 50 terminations online. In the last 4 or 5 years, we've probably done several hundred online. It's now the default. So things change. And with accommodation, the bar continues to rise as well. But the key thing I want to say, and I want you to take this away, just like the hire slow, fire fast, is accommodation requires a reasonable, not a perfect solution. So it doesn't need to be perfect for either party. It only needs to be reasonable. And a lot of times, and I just had this conversation with a client, Matt, where the client said, no matter what, we want to accommodate someone. Well, if it doesn't work for your workplace and you've gone through the process of accommodation, you might reach what's called undue hardship. And once you've reached undue hardship, then you have met as an employer your duty to accommodate. And then people on the line are probably wondering, what is undue hardship? Well, it's an individual fact-based analysis, and it's largely dependent on the situation. But an example of undue hardship would be if you had a visually impaired bus driver operating for the BC Transit Commission, and they had a degenerative eye disease that caused them to be visually impaired. Well, obviously they can't operate a bus. That would be undue hardship. So there's a whole host of factors to look at, but just know that it requires work on the employer's part and also work on the employee's part. So that's accommodation. We could do an entire webinar, Matt, on accommodation, and maybe it's something, depending on the uptick, maybe we can do an accommodation webinar in the future. I want to move on now to performance management, discipline, and terminations. And I want to say that I want you to think of performance management as an umbrella, because under performance management is the following: feedback, coaching, performance reviews, discipline, and a whole host of other things. Even something like performance improvement plans, Matt.
Right.
I don't know if you've ever dealt with performance improvement plans, but that's where someone's not performing and then you put them on a plan. And one of the questions, and they're otherwise known as PIPs, performance improvement plans. And one of the things, Matt, that clients will often call us on the legal and employment law side. And performance management, by the way, is another great module that I can speak about our own company. It has greatly simplified our performance management process using our HUMI technology, because the great thing about HUMI is it's customizable. So a lot of these other technologies, it's an all-in-one solution, whereas with HUMI, you could use the performance management modules, but you can customize it to your own organization's KPIs and objectives, which we did. And it greatly simplified our performance management process. So thank you to the team at HUMI for that. But anyways, Matt, you had a question.
Yeah. So what are the legal considerations when implementing like a performance improvement plan or PIP?
Yeah, it's a great question. And for those of you on the line, this is just formalizing performance management. So if you're coaching someone, before you get to progressive discipline, they might not be cutting it. So you're putting them more on a formal plan or formal document that's going to give them a bit of a time frame to improve their performance. What I say to clients is this, Matthew. If a client calls and says, I want to put the person on a PIP, the reality is this: if they're not going to make it, if there's a very low likelihood that this person is going to improve, then don't go through the process for the sake of going through the process. I would only go through the performance improvement process or plan if there's a good likelihood that they're going to be able to improve. Otherwise, I wouldn't bother, because it is something that can be used against you down the road. But it's a great question. And then unfortunately, if performance management, doesn't work, then you unfortunately have to resort to discipline. The golden rule, of course, is to correct behavior, not to punish, because progressive discipline is not about punishing, it's about correcting behavior. And this is my kind of spectrum of discipline. Now, I have feedback, support, and coaching as a separate color here, Matt, because it actually precedes progressive discipline. And you can even have another box there about performance management. But at some point, you're going to get into verbal warnings, written warnings, suspensions. If it's really serious, like we use this a lot in substance abuse cases or cases where, and we call it a last chance agreement, where a company might have reasons to terminate someone for cause, or they've reached the end of the line. But instead of termination, you want to give them one last chance, and then they have to meet certain conditions. So again, this follows, it's progressive, a series of steps, but it's very important to understand that if someone does something really serious, like sexual harassment, theft, gross insubordination, a serious health and safety violation, then you're not going to give them a verbal warning. You might go straight to termination. So it's progressive, but it depends, again, largely on the situation. And I want to just say, Matt, that you always want to consider mitigating factors with discipline. And those are things like how long the person's been at the company, what's their past record of service, what's their service, how have they performed, are they going through we're all going through stuff in our life, Matthew, like whether it's kids, elderly parents, financial considerations. So you always want to consider kind of these mitigating factors. It doesn't mean that someone's behavior is excused or justified. It's just something that might change the level of discipline that you impose in that situation. So I hope that makes sense.
Yeah, Jordan, I have a question from the
Yeah.
audience here.
Yeah.
Can you please explain how doing a PIP could work against us in the future?
Yeah. So in simple terms, the way a PIP works is if you go through a PIP process, and it's clear, and we've seen this in our legal practice many, many times, where a client does a PIP simply to check a box off. So simply to, and it's kind of like, rather than put an employee through a miserable process for 3 months, knowing full well, it's kind of like you knew as the employer or manager that they weren't going to make it at the outset. Why put them through it? If it becomes blatantly obvious, like you keep moving the goalposts of the performance improvement plan such that the person was never going to achieve the goals, that could be used by a third party, whether it's a lawyer, whether it's, someone on the other side, to basically say, like, you didn't even give my employee a chance. And that could potentially result in higher damages because you haven't treated the person in good faith. That's really the simplest way to explain it. And remember what I said at the beginning, Matt, we want to reduce risk, but we want to do it in a dignified and respectful manner. So that's kind of what I want everyone to leave here with today. We want to do it in a dignified and respectful manner. So I want to just wrap up. I want to be mindful. There's a ton of questions that's been asked. So I want to go through this last section fairly quickly. There's something called just cause, and there's something called without cause. Some different concepts in Quebec. In Quebec, they call it, the specific phrase in Quebec is serious fault, which is just cause, or just and sufficient reason, which is without cause, but it has to be after the 2-year mark. You have to have just and sufficient reason only in Quebec. And, in terms of just cause, what you need to do is you have to ask 3 questions. And the first question is, what's the misconduct? What happened here? The second question is, you need to ask all the contextual, what are the circumstances around the misconduct? And then the third question, which is the most important, can the workplace situation and relationship continue in the future? And if the answer is yes, then maybe it's not termination. If the answer is no, that's when you would terminate. Now, unfortunately, what they've done in Ontario, Matthew, is in the last couple of years, they made it more complicated. And they made it more complicated because they have created two levels of cause. Okay, there's something called cause at common law, like all the case law over time. And what that means is when you terminate someone for cause, and I'm speaking only in Ontario right now, and you do something really bad, but it's not considered willful misconduct, then you have to give them their employment standards minimums in Ontario. However, if you terminate for willful misconduct, so this is very serious, deliberate, and willful action, then you don't pay them anything. This hasn't been adopted in other provinces, and I'm going to talk about this briefly. But in this render decision, Matthew, what happened is a long service employee smacked a female's behind in the cafeteria 3 times in the presence of a number of other employees. And they were terminated, and the company said, we're terminating you for cause, and we're not giving you anything. It went to the Court of Appeal, and the Court of Appeal in Ontario said, when he smacked the individual in the workplace, which, in my opinion, is gross misconduct, not only willful misconduct, but gross misconduct, the court said he didn't really go in there deliberately to smack the employee or slap the employee. So we think he should be terminated, but he should be paid his minimum ESA entitlements. It's a very controversial decision, but that's where we're at in Ontario. The other provinces, namely BC, in the Bessie case, this is a case where they haven't adopted these 2 levels of cause. And basically in Bessie, this individual misappropriated 51 hours of time on a timesheet, which was viewed as theft and was paid nothing, according to the BC court. And so that's kind of the law right now. The last thing I wanted to mention is, which is the vast majority of cases where you terminate someone without cause. And again, coming back to, if you have an employment agreement, as I talked about, the most valuable thing, should have it reviewed. You can rely on the employment agreement, which is what you want to do. If you don't have an employment agreement, which is the vast majority of employers not having a good one, you have to look at the following factors. You have to look at the person's age, service, level of employment, level of compensation, and how long is it going to take them to find a comparable job. And so it's kind of like that game, Matthew, when we were kids, pin the tail on the donkey at birthday parties. So if you have an employment agreement, you're not wearing a blindfold. You can go and you can put the thing right in the bullseye. But if you don't have an employment agreement and you want to terminate someone without cause, and you have to resort to common law, you don't know where it's going to land. And it can be vastly different and very costly for employers. I put in this IBM case because it's one of the longest cases in Canadian history, 27 months. A lot of people think the longest possible severance is 2 years, but it's actually 27 months according to this case. And it's just something that, the group should be aware of. So Matt, it's we're 48 or so minutes into it. There's been some great questions. So what I want to do at this point is I think I want to first I want to just tell the group on the line here that we do have an HR checklist, an HR fundamentals checklist if you want to scan here, and a 30-minute consultation from one of our HR gurus if you want to do this. But what I would like to do, and I think this is going to be sent out after the session, Matt, by your group.
Sure.
But I want to just get into the questions because I think there's been some great questions here. And
Yeah, for sure.
yeah.
I do have one question I'd like to start off with, and we can ramp it over there. But what would be like in your best practice advice for conducting terminations?
Yeah, it's I mean, look, our HR team, I have to say, just because of the nature of the clients we work with, the value of having a professional at a termination meeting, I can't understate, because you can have the most sophisticated manager and business person that completely messes up a termination meeting, and it could have disastrous consequences in terms of like what it means for the company. So I think the most important thing, Matthew, and this, I'm not using this example for people that do really bad stuff in the workplace, but the vast majority of terminations, preparation, preparation, preparation. You should always have a script. You should always have a script with a step-by-step approach. And when you're giving advice to a manager, that manager who's doing the termination should always follow the script. And that termination meeting, both before the meeting, during the meeting, and after the meeting, it's all about the individual. So you want to treat the individual with the highest level of respect, because that's what they're going to remember. They might be completely pissed off that they're terminated, but they'll remember that they were treated well in the termination meeting. So,
Right.
so that's the advice on best practice. So preparation and treating people with dignity and respect would be the two kind of main things I would say.
For sure. I've collaborated a couple questions throughout the webinar, so I'm going to ask them now to you, Jordan. But the first one, I think you might have answered, but when should a company create policies?
Well, there's, if you remember the difference between compliance policies, which are the must-haves, and then the best practices policies, which are the should-haves. I think, I think even a startup company should have a framework of policies, because policies constantly evolve over time. And when there's new legislation that comes into play, like even in the last year, there's the Workers for Workers Act, which had a number of pieces of legislation in the province. I'm using Ontario, forgive me, but there's similar legislation. There was a legislation in BC last year that got introduced that you had to share salary ranges in job postings, which is coming in Ontario, by the way, and you couldn't ask candidates what their salary is in the recruitment process. I mean, these are fundamental changes. So you obviously have to have policies for these things. So I don't think there's a good time, but I think you should start with a framework of key compliance policies and gradually build from there. And that's where you want to get to, and you should be conducting an assessment of these policies on an ongoing basis.
Right. And Jordan, like very similar to this question, like is it just enough to rely on these like on an initial employment contract without creating additional policies?
Yeah, as I said earlier, Matt, you definitely don't want to have a policy embedded in an employment agreement, because if there's a conflict between an employment agreement and a company policy, the employment agreement will prevail, will trump the company policy. So we are big proponents, both our lawyers and our HR professionals, to have a clause, we call it the catch-all clause, which is a policy clause in your agreement saying you will be covered by policies and procedures that the company may introduce and amend from time to time. Because if you have 10 policies in your employment agreement and then you introduce another 5, that employee can say, oh, I'm not covered by these other 5 policies because they're not in my agreement. But if you have language that is customizable to policies that are introduced over time, as you're introducing these policies, send them through HUME, have them read and signed off, and again, socialize them. And then you're set, because the employee has signed off and it's covered in the agreement.
Well, this is
So,
a great segue to the next question then. So, what can we do if an employee refuses to sign an updated version of their letter of employment, or with a new complete clause, or any type of policy for that matter?
okay, again, companies. So I'm going to get to the non-compete in a minute, because some provinces non-competes are actually illegal right now. That you can't actually introduce them. So introducing clauses are different from policies. A company has the right to introduce policies at any time. Now, I would say I wouldn't introduce a policy and say it applies, it's effective tomorrow, but a company has the right to do that. And I would say it's a performance issue if an employee is refusing to sign it. Obviously, you'd want to ask, why aren't you signing it? And you'd want to give them every opportunity to sign it. But at the end of the day, if they didn't sign it, I hate to be harsh here, but they might not have a job at your company. So if you had a harassment policy and you were insisting on your employees to sign off, and they're like, "Yeah, I'm not signing off. It's not part of my employment agreement," and you had good language, it's kind of like, you're going to sign off. Similarly, even if they don't sign off, but they continue to work under those terms for a number of years, then they've essentially accepted the policies as is. But the company can introduce policies from time to time.
Okay, right on. We're going to shift a little bit over to another question here.
Yeah. Great
How?
questions, but great questions, by the way.
Yeah, I like them. I like them. They're not from me. But Jordan, how long do someone that asks a question need to continue benefits for someone on a disability claim and no longer employed?
Wow, this is a tricky question. So basically, I'm going to answer the question as a lawyer would answer the question. It depends. But when someone's on disability, that's when they really need benefits. So you certainly don't want to cut them off benefits. If you do have a policy, Matt, and some insurance companies will allow you to do this, and you could have a company policy saying after a certain number of years, the policy will be discontinued, like the benefit policy will be discontinued. What you need to be aware of as an employer is a potential human rights complaint. So you've cut off their benefits and you've prevented them from accessing benefits. So you've discriminated against them on the basis of disability. No different than, another form of discrimination where you're treating someone differently. But I would say a number of our clients have moved gradually over the years to, after 2 or 3 years, being able to discontinue benefits if they want to do that, if the person is on disability for a long period of time.
Mm-hmm.
But it's not a practice that I would certainly openly endorse. I think you got to do it on a case-by-case basis.
Okay, right on.
And get legal advice before you do it.
For sure. How to implement accessibility policy in a fully remote company?
Well, I think I think it's like asking the question. It's a great question. It's like, how do you implement health and safety in a fully remote policy? How do you implement other policies? For example, if you have a substance abuse policy that you can't use alcohol and drugs while at work, and you're working remotely, but you're smoking weed every day, that policy is going to apply to you equally if you're driving an hour to work or if you're working in your home office. The same policy is going to apply. So the principles, accessibility in the vast majority of Canadian provinces is one of those mandatory policies, Matt. So it would apply, obviously would have to be adjusted and amended to reflect a remote work environment, but the same principles of, the whole thing about accessibility is we want to create an environment. Accessibility is not about creating, ramps for people with wheelchairs and hearing aids for people with hearing impairments. It's to create behavioral change so that when you see someone with a disability, you don't think of them any differently. So it's the same thing that when you're operating in a remote environment, you want to adapt. And the best way to answer the participant's question is get input from the people in the company that have a disability and that have disclosed that as to how you should create a policy to reflect a remote environment. Great question.
Awesome, awesome. So we are getting to the end of time right now. I feel like we could have done this webinar for 3 hours, Jordan, but thanks for putting that all in there together within 45 minutes. Thank you all for joining. I really appreciate your time. So happy to have you guys as customers. For those that aren't customers, by all means, come explore us at Hume, and feel free to reach out to Jordan over there at MaxPeople for HR and furthermore legal advice. Again, thank you guys all for your time. And we will certainly follow up with an email, and we hope to keep in touch with you all.
Thanks, everyone. Have a great day. Thanks, Matt.
All right. Bye-bye, everyone.